Good morning, everybody.
Good morning.
Good morning. Welcome back. I'm glad that all but one of us made it back, and hopefully Thomas will be here in a minute. I want to thank you all again for the really good discussion that we had the last couple of days. I thought it was very productive and interesting, and you all raised really good points to think about. So going forward, I think there's a few items that we still need to discuss. When we left last time, we had kind of laid out the provision defining religious mission in 600 and how that related to provisions in 602. I'm not sure people had an opportunity to discuss that as much as we wanted. I think people were tired and ready to leave for the day. So if there's more discussion on that, I thought we would start there. And then we did not discuss 600.9 and 600.11, which were added to our agenda later. So I'm hoping that we can do those this morning. And then tomorrow morning, we got a question from Richard about the FAFSA, and I have somebody from our Federal Student Aid Office coming to address how the FAFSA works and how income from religious orders would work into the FAFSA expected family contribution. So he's coming at 9 tomorrow morning. And then that will leave us basically a day and a half left where we should really think about what the subcommittee wants to present to the full committee. And if there's things in the administration's proposal that you don't like, that was just the administration's first cut. They're very interested in getting consensus from the full committee and are interested in compromising and thinking through alternatives. So if you want to put another proposal on the table, that's fine. If there's compromise language, if there's anything we can do to reword things to make it better, we're definitely open for that. And then we need to think about whether there's one proposal that the whole subcommittee can get behind and present to the full committee, and if not, whether we can create options and how you would like those options to be presented. So we will start that as soon as we finish going through the items that we haven't. Good morning, Thomas. How are you? You're welcome to put your jacket in my office if you would like to. Okay. So we had just started, and I think we'll pick up with the discussion of 600 and 602 that we ended with last time, and then this afternoon we can move to thinking about what we would like to present to the full committee. Does that sound like a good approach to people? Sure. Okay. So in 600, the red line on 600, which is a pretty thick one, on page 7 at the top is the definition of religious mission that we laid out last time, but I imagine that you may want to discuss that a bit. We had kind of a rushed conversation. Does anybody have comments or questions on that? Oh, Richard, I'm sorry.
Okay. Okay, how about that? No, we'll share. Yeah, so I was wondering whether the department's received any complaints based on the fact that the term religious mission was undefined in the regs so far. And if so, what were those? Who did they come from?
I'm not aware of any formal complaints, but this is an issue that has been raised to us at conferences and other conversations. Just making sure that accrediting agencies recognize religious mission and recognize it in a holistic way, not narrowly tailored. But encapsulating, housing and governance and those kinds of issues.
So if the department hasn't received any complaints, on what did it base this definition? Did it come from statutes, from regulations, from case law, from other sources, from
I believe there's a very
regulation?
similar definition that was in the Prosper Act.
Which was not passed.
That's correct. That was the House bill to reauthorize the Higher Education Act that was not passed. Yes. Stephen?
Yeah, if I believe I'm correct, but it's religious mission is referred to several places, but there's never a definition of what it is that accreditors have to take into account the religious mission, but there's nothing that says that's what this is. So I think something like this is important, just to give accreditors an understanding of what the department means by religious mission.
Just a quick question, and I'm looking for my paperwork, but I don't seem to find it. So last time we spoke about the interest deferment on student loans for those individuals that participated in religious missions. How much discussion or overlap has there been about that definition of religious mission versus this definition as it relates to the accreditation? Is there any concern that we're using the same term and it could potentially have different meanings?
I think we need to look at that a little more carefully, but the intent, I believe, was to use the religious mission definition anywhere that it's referred to in the regulations, so that it would be consistent. Well, actually, I need to think about that a little bit, because it says an institutional mission, and in the deferments, it's not necessarily an institution. So,
Yeah, I don't have an answer either. I just wanted to at least raise it and see if I don't want to get tripped up later on.
So I asked a moment ago about complaints about the lack of a definition of religious mission. Now I want to ask a different question, but also relates to what complaints the department has received. And that has to do with, has the department received complaints regarding accreditation relating to religious missions? I think from what we heard last time, it sounded like the answer is no. Is that right?
we haven't received formal complaints. We certainly have had people who have raised concerns about that, particularly with respect to HLC. They proposed a change that they ultimately decided not to implement, but there was a lot of discussion around that at that time.
What were those concerns?
There was concerns that HLC was not going to be looking at religious mission when they, and Kim, you're nodding. You might have more information than I do. But
Right. I'm trying to remember as well, but there was concern that they were changing their own standard for what they would expect of an institution to have as its mission. And of course, that's a departure from just the general approach to higher ed under the HEA since the mid-60s, which is that the institution defines its mission and the accreditor respects that definition or the sense of that mission, and is basically looking to see that in carrying out its mission, the university is, or the institution is meeting certain standards, but it's not the accreditor's job to define the mission for the institution. And there was concern that the HLC was moving away from that.
So I can imagine a definition like this being helpful to accreditors in one sense. You were talking about the difference in the application of this and deferment policy, that sort of thing. This is referring to an institutional mission here, but it seems to me that's because this religious mission phrase in 600 is about institutional eligibility. And so, of course, as a social scientist of religion, there's a notoriously long problem of defining religion from a just a scholarly standpoint. But I think this conveys the sense in which that's relevant to this standard. So it's a stipulated definition for a function, it seems to me. But as long as that's clear and it's not an attempt to define what religion is or isn't, that would, I think, be a much more complicated and controversial task.
Let me step back for just a second. How many institutions have lost their accreditation because of a dispute over religious mission?
I'm looking to Harmon Bounds, who's our Director of Accreditation. And I'm not sure we would know that.
I ask because I've certainly never heard or read any reports of anything like that. Have you?
No, I haven't. Yeah, I just don't have that.
So then I guess I'm still struggling with trying to figure out what the concern is here that's driving the department's proposed change in the language.
I think the Attorney General has asked us to look through all of our regulations to be thinking about whether they are appropriate in light of Trinity and other case law, and this was part of that. It was not being driven by a complaint, nor were any of the provisions that are being proposed.
Well, then how does this relate to Trinity Lutheran? How is this definition grounded in Trinity Lutheran?
I think there is an interest in making sure that we are not infringing on institutions' free exercise of religion.
Did the department receive, and I don't know if you can, it's a pretty specific question, I don't know if you can answer it, but did the department receive a complaint from Gordon College related to the New England review process they were forced to go through?
I mean, we could certainly check, but not that I recall.
Just in answer to Richard's question about what's pushing it, I think it's a general concern across the board that there could be a situation where the Gordon College, I'll say threat, I don't know if it was a threat, but there was anxiety about Gordon College losing their accreditation because of their religious mission or things that were important to their religious belief. And I think that's what's underlying this.
Because that came up before, I've been doing some reading about Gordon College. I don't pretend to be an expert in what went on, but as I read it, the college didn't lose accreditation, didn't have any threat of losing accreditation. It sounded from the stories that I read, and there are a variety of them from a variety of sources, like it was the process working like it was supposed to and turning out, just fine from the college's perspective. Maybe I misunderstood something, but again, that feels like dramatic rewriting of regulations for something for which there was already a system that took care of it. Seems surprising to me, given that there are settled expectations around existing regulations.
So I think at the time that the Gordon College issue was going on, it lasted for about a year. And of course, the problem is that students are making a decision about where they're going to go to college. And so if there's any threat to the accreditation of an institution, it's very likely to affect decision-making by the students and their parents as to whether that college is on the list of possible places to go or not. And so especially in the private sphere, this would not be a concern so much for public institutions, but in the private sphere, even the threat of a possible loss of accreditation for even a year while an investigation is going on, especially if it's during those crucial months when students and their parents are making decisions about what school they go to, that can be really an existential threat to these institutions. And so in Gordon College, the situation, there were several months in which it was not clear what the accreditor was going to do. I mean, the accreditor said it was investigating Gordon for its religious beliefs, which is what ties into Trinity Lutheran and so many other Supreme Court decisions, which is when there's a sense that an institution is being targeted and investigated for its religious beliefs. I mean, that's really not supposed to be happening under our Constitution. And so Congress has been very clear since the 60s that the creditors really are to defer to the institution's understanding of its mission. It added language specifically protecting religious mission, I think back in 2008 or so. And so clearly, even back in 2008, there was enough of a concern that religious institutions might be targets and might suffer very severe harm if their accreditation is called into question at all, that Congress acted in 2008. And I think it makes a lot of sense for the department to provide a national definition so that there is uniformity and consistency. I think that's the name of the section of the reg. I don't have it right in front of me, but typically when we're talking about the application of a statutory standard by the federal government, you want some sort of uniformity and consistency, and it seems like the first step for that is obviously to define what religious mission is so that the accreditors across the country have a uniform guidance from the department, and then that hopefully allows the accreditors and the institutions and the students to know exactly how this is going to be applied and to have some real assurance that religious mission is going to be respected. And we've seen Gordon College have an issue raised about it that hung over its head for quite a while. We've seen situations in Canada where students are not allowed to sit for the bar because of the religious beliefs of their institution, and we want to prevent that from happening here.
Thank you. So I appreciate this discussion, but given that accreditors are asked to respect the religious mission of institutions, it seems helpful to me functionally to have a definition. The challenge, I think, is in what that means operationally, and that's where we've had some other discussion in, I think, 602.18. And so, but I think it would be helpful for accreditors to know, because this is not respecting, this is beyond tolerating, and so it suggests some kind of positive attitude towards and accommodation of, but I don't know. And so that, I think, requires more than just the word. So you have a sort of nebulous concept that doesn't have any legs to it. So I think it's helpful to accreditors to have a definition, but again, how that respect is discharged, or is shown as satisfied, is a more complicated discussion, I think.
A couple of thoughts. Well, I mean, first, of course, Canadian schools aren't regulated by the department, but even if they were, that isn't the basis on which there was a question about sitting for the bar. But what I'm really wondering here is, this is an attempt to define one particular kind of a mission, and I have two thoughts. So this is one, and Tom and I were just kind of chatting about this. I don't think there's ever any other situation in which the department defines what a mission is, but instead says to accreditors, respect the mission of the institution. It seems peculiar to me to be defining religious mission and not other mission, or not mission more broadly, or something that the sort of the singling out and treating religious missions differently than all other institutions in a system that's supposed to respect the mission of every institution strikes me as is peculiar, and so I would appreciate some explanation of the department's thinking on that. I also wanted before that to say one other thing, which is that the timeline on these things, I think as we talked about last time, and it may have been something that you told me as well, I don't think a year is unusual. I think that's sort of normal for accreditation, isn't it? Isn't that what you, yeah, because Tom was saying last time Fordham had just gone through their process. It was a year, and, and it's a process. And so this thing about the long timelines, I mean, I think that there was nothing, I don't think there was anything unusual about the Gordon College timeline, but I also don't think that there's anything unusual about those timelines in general, because it's a complicated process. The thing, though, I guess I would like to ask the department to focus on and explain is the rationale for defining and treating this kind of a mission differently from all others in a system that is designed to say we respect all missions of all institutions.
So I think in a way you were mixing apples and oranges, and that is that this, the normal process of an accreditation being a year long or reaccreditation is a different situation than what Gordon was facing, because Gordon had a complaint made against it to the accreditor seeking removal of its accreditation. And that's a very different situation than where it's just going through its normal reaccreditation process that all institutions do. So I think there has been a problem fairly recently that showed the need for definition of religious mission, and it makes sense for the department to focus on that, not only because there have been concerns raised. Now we've named a couple of three different contexts, and I'm sure there are more, but also Congress itself, pulled out, specified religious mission as a particular concern. So it's not that the department is singling out religious mission to define on its own. It's that it's actually following the lead of Congress that singled out religious mission for a particular concern.
And Richard, to address your question, if you're interested in defining mission more generally, that's something we certainly can talk about.
Well, maybe. I mean, what I guess I'm more interested in is if the system is designed to take institutional missions as a given, whatever they are, then to impose a definition on that seems, for a subset, seems peculiar, and I assume that there must be a rationale for that, but I guess I'm struggling a little bit with what that is. I also had a more specific question about this definition. I just want to get the language here so I've got, so that I've got it right. So this talks about sort of including within the mission housing, student life and activities, employment, self-governance, student admission, continuing enrollment, all of that stuff. I don't really know enough about the accreditation process to know, are those all things that accreditors and I know that other people will, whether accreditors normally assess those either with respect to the institution's mission or otherwise?
So I just want to introduce, we have Herman Bounds and Nicole Harris and Charity Helton, who are from our accreditation group, and I am going to defer to one of them to answer your question.
Okay, thank you.
So your question is more difficult than it might seem, and the reason I say this is because all accreditors have different standards, and we really don't set those. But normally the accreditation process the accreditation standards are really related to, it'll go as far as maybe recruiting, enrollment curriculum, those types of things. Yeah, program length, and that's just a few. Not too much as, and maybe a little student life, but not so much as housing and those type things in the accreditation process. The accreditor may have some policies that they look at, that they apply to institutions. So it's a little different as to what they all look at as far as accreditation. But I can't recall, accreditation being withdrawn for something related to those issues, housing or any of those other things that you just spoke of.
Well, that again then gets to the question. That's another way in which it seems peculiar to be including those things here, if that's not something that accreditors are otherwise considering in the first place.
Yeah, and again, I would say all accreditors have different standards, and some of the, there could be some accreditors that do look at some of those things. So, without, having the standards of all, 60 or so of those organizations here, it's kind of hard to say. I just don't know of any accreditation that has been withdrawn because of some of those things, or we haven't got any complaints about any of those things from institutions. From the against the accreditor that I can recall. Nicole, can you?
No, not at this time. We can do if you have a specific type that you're looking for, because we did do the initial research on formal complaints to the department for religious purposes, and we gathered no results from that.
So thank you. That's helpful. I think some programmatic accreditors might have things like diversity standards, and they ask about non-discrimination practices at campuses and policies related to Title IX things and that sort of issue. And so I took this to be referencing that kind of scope of application, but so I have seen issues arise at a programmatic accreditor level that were resolved at the accreditation level, so I doubt the complaints went beyond that.
Yeah, I agree. That could be true. That's a good point. I'm glad you brought that up. Yeah, that could be true. Yeah.
All right, anything else on definition of religious mission? Hayden.
So I've been trying to formulate the thoughts and the voices of my constituency of lesbian, gay, bisexual, transgender, queer, and intersex young folks at religious universities and colleges. I'm trying to formulate what I'm hearing from them, in my head and in my heart, to something that is constructive. I understand why a definition of religious mission is useful, because religious mission as two words alone doesn't have a whole lot of teeth or shape or weight to it. I understand that there is some usefulness and why there might be hunger for that. But my constituency would also be curious why other missions would not be protected, elevated, of equal consideration. Because we've brought up Gordon College a lot here, and it feels to me, I know that I'm coming from a particular perspective, but there is a strong subtext here around how religious mission and LGBTQI concerns meet on religious campuses. And I feel like those words need to be said out loud. That needs to be human and in here in the room. because this isn't just words on a page. This is young folks who are being kicked out of their schools or outed to their parents or losing their scholarships. And that stuff is really hard. And I want to make sure that we talk about the people as we talk about the institution. And so I think what I'm kind of hearing and feeling from my constituency is that other missions are valid too, including missions that would forefront the protection of minorities, of LGBTQI people, of other perhaps discriminated against identities, that is of equal measure too. So I hope that we would at least give equal thought and time to other kinds of missions, other ways that institutions live out their ethics.
Thank you. Bill?
So along those lines, I'm thinking, for instance, there are active duty military training contexts that have accreditations. And, you know, there are policies now that require a session eligibility to the military to enter those programs and matriculate through them. And that certainly has all sorts of implications for what people can go into the programs and graduate from them. And so would that be part of the scope of respecting mission, that accreditors would work with military contexts to, so I understand that it probably is a similar kind of thing. So that's a very different mission, but one where it seems like accreditors routinely accommodate the distinctive requirements that would be odd in most other settings. So I couldn't go back on active duty now because of age and certain other characteristics. So for instance, and I think, and yet I don't think that would be a challenge to their accreditation given their mission of having people that are service eligible. So at any rate, it just seems to me like the most concrete alternative example of a mission that's clearly accommodated and understood by accreditors.
Haven? Oh. All right. If there's nothing more on that, let's turn to 602, which is another thick red line section on accreditation. And on page 14 and 15, there's some language relating to the religious mission. So this is has everybody found the place? So it's the red line in 602 on page 14 at the bottom. So 602.18. This is the language that requires accrediting agencies to respect this stated mission of the institution, and then that language specifically references religious mission, as I believe the statute does as well. Is that right, Herman? Yes. So that's one reason that we may want to define religious mission, because both mission and religious mission are referenced in the statute and the regulations. And then on page 15, a lowercase b, the department's proposing new language that says, at the request of an institution, performs review of the accreditor's respect for an institution's religious mission and provides a written response of the results of that review. So this would be an institution requesting the accreditor to review and provide the written response.
So here's where I've done some alternative suggestions, but before I launch into any of that, what do we understand this proposal to mean? There's something like an accrediting body does a kind of like self-study around this one point, if asked? I mean, how does that actually play out operationally? I'm not really clear about that.
I think this is an internal review by the accrediting agency of its own process. And we certainly can think about how to make that language more clear or think about whether that's the right way to frame it.
If I could just follow up then, because, but then providing a written response, I suppose, to the requesting body, is that the idea?
Yes.
Okay.
Am I to understand that with regard to the language in B on page 15, that request could come at any time during the accreditation process, even at the onset of the accreditation process? And so am I missing anything in that there's really no element of time here relative to the accreditation process?
That is correct. As it's written, there's no element of time.
So I'm wearing these multiple hats from an accreditation perspective, also from a administrator in a faith-based program. But I'm trying to think through what this does. I mean, so let's say a program receives this report and they're not convinced the program's done a good job. Is the idea just shining light on the process and forcing self-scrutiny as somehow a protective measure? Or I'm wondering exactly what this is trying to be a preventative for or to remedy.
I think that's right.
And if the receiving entity felt that it was not adequate, or that clear bias or some violation of their religious liberties had occurred, then is the presumption that it would avail itself of whatever appeal or complaint mechanisms are within the accrediting body's procedure or through the Department of Ed?
Yeah, Herman, do you want to address what options might be available?
First of all, I would assume that this would take effect, before the accreditation process, so that the two entities could work out any differences, so they could be brought out in the open ahead of time. As Lynn and everybody was saying, this can happen at any time during the process. So I would assume that the institution or program would be able to then follow the agency's complaint processes to look at things that the institution program thought that the agency was not being considerate of, and then that process would work itself out. And then, of course, at the end of that process, the other option is for that institution or program then to bring those issues to us to look at it as part of any other complaint process. But I think it would have to start at the level between the institution and the accreditor to follow those complaint processes and see if they can figure that out. But as I've always said, hopefully the whole accreditation process being voluntary, this reinforces that, but it also reinforces the fact that, hey, the institution and accreditor should be looking and working through those things before they get too far down, before they get too far down the process. I hope I answered your question.
Just a quick follow-up. So, based on your reading of the language as it's currently proposed, it doesn't sound like an institution would be limited in requesting more than one review. So they could do a review at the beginning of the process, they could do a review in the middle of the process, they could do a review at the end of the process. Is that, A, how would that play out, and B, is that what the intent of this is?
Yeah, you're right. I mean, it could happen at any point. I just think the intent of it is, and I'm not sure of the intent, but I would think that it is to allow the institution the opportunity to look and say, hey, you know, we have a concern and we would want the accreditor then to go back and review its policies and procedures related to that, you know, related to religious mission. And I guess, you know, folks, they want to get ahead of any issues or concerns that may arise. So, yeah, and it could happen at any time.
Yeah, I've been thinking about how Bill explained to us the process really helpfully last time, and some of the concerns that he raised about adding on to this process, and I guess and particularly why in this context, I'm sort of wondering if there's a problem with accreditors not respecting the missions of institutions, which is their job in the process, then I'm not sure why this is limited to religious missions. And I'm also, from what the department has said, it doesn't sound like there's been a loss of accreditation. There haven't been complaints. That in both senses, it's striking me as odd to single out either there's more of a need for process for every kind of respect for missions, or there isn't. And so I wonder what the rationale for this particular limitation is, as opposed to saying we've received lots of complaints about not respecting missions, and let's open that up and have more process. And yes, that's going to be immensely burdensome for accreditors, but that's life because that's what we, the department, want, or there just aren't problems.
And I think if you want to propose that we look at mission more generally, we certainly can put that on the table and talk about that.
Given that A seems to set the context here where this occurs is when an examination of the program's compliance with agency standards is occurring. And so I'm wondering, for instance, again, operationally here of what's envisioned. So a trigger for asking for this kind of a self-review by an accrediting body. For instance, what if a deficiency was articulated that the accrediting body did not understand was related to the mission, and it wasn't identified as related to the mission by the submitting institution, but then after the fact they say, well, of course it is. It seems to me like that's a sort of nebulous process that could really make accreditation review quite convoluted. I could see it if a program identified, because of our religious mission, we do things differently a bit than how it may be typically, the standard may be met by other places. And then it seems like it would be a really relevant thing to apply. But I don't disagree with the idea that demonstrating respect for religious mission is the burden of accreditors. That makes sense to me, like respect for any area of diversity that accreditors value. In this case, this is prescribed by the regulations, but in many cases it's by their own principles of respecting diversity. And so I'm not trying to say that that shouldn't be where the burden lies to demonstrate respect, but for this to be a feasible process, it seems to me that there has to be some kind of clear line of expectation of what programs self-identify when they're saying that a compliance gap may result from a religious mission or something of that sort, to use this language. And rather than a sort of post hoc, anything goes kind of wild card you can play to protract and put pressure on an accreditor. And it's not just protecting accreditors here. It seems like that sort of so complicates the process that it becomes an unhelpful review then.
So I want to go back to the bottom of page 14 where we have the existing regulation. The agency must consistently apply and enforce standards that respect the stated mission of the institution. And then we have including religious mission. But that's not it. Religious mission here seems to be a subtext, whereas the line in B only applies to an institution's religious mission. So I'm wondering if an institution had, let's say, an equity mission or an opportunity mission or an access mission, would would the rights being proposed here by that institution to ask the accreditor to perform a review, would those be available as well, or is this just limited to the religious mission as it's outlined?
As it's outlined, it's limited to the religious mission, but we can talk here about proposing something different.
I mean, I was largely thinking down the same line as Andrew, but it's also present in C, Part C on page 15. Result of an institution's adherence to its religious mission. Yeah, I am unclear on what data would inspire offering these provisions, but only as remedy to schools with religious mission issues vis-a-vis accreditation. If we are about respecting the mission and creating latitude for that, then I would think it would apply to all missions, not just religious missions. And I'm just still kind of curious what the prompting problem is. And then also it does seem like separately there's a logistical issue to be resolved here. It seems complicated.
So I came across an article in the Chronicle of Higher Education. It's from 2014, and it's called The Great Accreditation Farce. And I think it kind of captures what some of the concern is about what could happen in an accreditation process where one of the accreditors, on the visiting committee, one of the visitors, just doesn't understand what religious mission looks like, and also maybe has even some hostility toward it. And I'm not saying that happens as a general rule. I'm on a board of a religious institution that went through the accreditation process and, was pleasantly surprised to find that the visitors were very conversant with what private religious education looks like. But if it's all right, it'll take just a little bit of time. But the person who wrote this article in the Chronicle of Higher Ed mentioned that he had been a member of a visiting team to a non-religious institution. So he had familiarity with the accreditation process. And basically, he's saying that in his view, and I'm reading now, that providing accreditation to colleges like Wheaton, which is, I think, universally respected as an educational institution, but it's quite religious. He says, providing accreditations to colleges like Wheaton make a mockery of whatever academic and intellectual standards the process of accreditation is supposed to uphold. And he's saying that because Wheaton requires a statement of faith of its faculty, which is an extremely common requirement. But he's very upset about that because he sees that as some sort of violation of academic freedom, which I think in practice it's not at all. But if accrediting agencies are playing by the rules in this continuing fiasco, then the rules have to be changed or interpreted more aggressively so that respect for belief systems does not entail approving the subversion of our core academic mission by this or that species of dogma. And then he becomes very sarcastic about religious colleges. I have a profound objection to legitimizing such an association through accreditation and thereby conceding that the integrity of scholarship and teaching is merely negotiable. I also object to the expenditure of taxpayer dollars, which of course would be student assistance, in support of religious ideology. So if you have a person, if you have this kind of accreditor, and he evidently does accreditation visits, on a team going to a religious college, that and there's some negative response as a result, this kind of article, I think, is part of what triggers the real concern, because we're increasingly seeing people who don't just understand necessarily what religious mission is and exactly how the religious colleges operate, and there can be some hostility toward that. So I think this rule is trying to to make sure that religious colleges can be assured that if they sense any problem within the visiting team, that they have a means of redressing that by asking the accreditors to, just look again at how that one particular visiting person maybe reviewed it and have an opportunity to get a written report as to what the accrediting agency finds from that.
The concerns, Kim, that you just stated would seem to me to, if they're valid criticisms of the process, as opposed to, I mean, what you were reading is an article that is about, that is one person criticizing the process as it exists because the author apparently thinks, apparently having seen how things work, thinks that there's all the respect being accorded to these institutions, and perhaps doesn't like that, that would underscore that I think the accreditors really are respecting the mission. But I guess the bigger thing is if the concern is right that an accreditor may dislike certain aspects of a mission of an institution, I don't see where that is any different for any other mission than it is for religious missions. It seems like that's a statement of a general problem that for which there should then be consideration of a general system to correct it, of which religious mission is just one of all the different categories of missions for which you'd say, are the accreditors really taking this seriously? Again, if it's a real problem, that would seem to be the solution.
Go ahead. No. Okay. Well, I just would, I think if there were a problem in other types of institutions, then certainly that should be addressed as well. But I think we aren't hearing that there are problems in other types of institutions, at least that have come up, but that there is a very real concern about just generally attitudes like the ones I just read that could be coming up in the accreditation process, specifically as to religious mission, because people may not understand what that looks like given their own, they may not recognize their own biases, of course, we know that. And so just having this kind of check that the regulation puts into effect, it seems a pretty minimal one to me. I mean, if it becomes subject to abuse by a religious institution, then clearly probably the institution has other problems that are reasons for it having an accreditation problem. And also typically, I think typically institutions are very reluctant to get on the wrong side of their accrediting agency, let alone the accreditors. So I think this would only come into play when the institution felt it had a very legitimate reason for, basically, this is basically throwing the challenge flag from the sideline and saying, I just like a review of that play just now to see if the call was right. And it slows the game down a little bit, but not terribly. And it does at least, allow for some redress by the accrediting agency early in the process, rather than having to wait till it drags out and, becomes perhaps a bigger problem or harder to undo the damage. I assume if the accrediting agency finds that there was a problem with that accreditor, they can kind of quickly get a different accrediting team or just a team member in there. So it seems like it's actually a good preventative measure, just in case there is some real reason for there being concern about an accrediting member's biases.
So I've been hearing a lot of discussion back and forth about why the religious mission language was added in the first place. Should we open this up to include other missions and different things like that? So I just wanted to provide a little bit of history and context that I think that might be helpful. So obviously, as we both know, the Higher Education Opportunity Act was the law that last reauthorized the HEA. That was HR 4137. The House side, the Senate side also had their version, which is S 1642, the Higher Education Amendments Act, or the Higher Education Amendments of 2007. Both bills had religious mission language included, and so in the conference report, that was accepted because both the House bill and the Senate bill had this language. Now, when we look at the report, if we go to the House report, there's a little bit more of context of where this language came from and what it means. So I'm going to just read this because I think it's important for this committee and to have it noted. So the new language requiring accrediting agencies or associations to apply and enforce their standards in a manner that respects the missions of institutions of higher education, including religious missions, reflects Congress' belief that accredited institutions should be allowed to choose their own missions rather than having them imposed or regulated by accrediting bodies. In response to concerns raised by Representatives Bobby Scott and Ruben Hinojosa about whether the amendment would harm the ability of accreditors to enforce non-discrimination provisions, the author of the amendment, Representative Tim Walberg, explained that the provision would not affect non-discrimination provisions and instead would require accreditors to respect the mission of schools, including when the missions are religious. It is the intent of the committee that this amendment does not change or alter current accreditation requirements and the exemptions included in those requirements, such as those allowed by the American Bar Association and the American Psychological Association, for the enforcement of non-discrimination provisions. The committee also notes that this provision does not alter Title VII of the Civil Rights Act of 1964, Title IX of the Education Amendments of 1972, or other federal anti-discrimination statutes, which remain applicable to institutions of higher education to the same extent as before. The Department of Education shall not promulgate any regulations that provide any new exceptions to current non-discrimination provisions. And I just wanted to articulate that because I think in the context of this conversation, it's good to get an idea of actually what Congress was thinking when these two words were even added. And I think that that can help us in our conversations moving forward.
Since we don't have evidence of specific schools being denied accreditation because of their religious mission, I think what we're talking about is preventatives for future hypotheticals. And so to me, it would seem that a universal remedy for all schools and all of their missions, regardless secular, religious, or somewhere in between, ought to be included and protected under the sort of remedies we're laying out in A through D.
Yeah, I found that really helpful. Thank you, Emmanuel, for pointing us back to the legislative history, and a couple of things. I mean, one is, so it seems to me that explains where the language, including religious mission in 60218 in the heading of it, comes from. That's very helpful. It helps us to know what they were trying to cover and what they weren't. Making sure that non-discrimination laws apply, and that they were using it to say they're not treated any differently from any other mission, and I think that's incredibly useful. One of the things that I'm thinking about that again goes to the if there's a problem, it's a broader problem. I certainly read and hear plenty of things that, as an example, criticize the missions of HBCUs or call into question. And if there's going to be a process that says it would seem to me that would be something that we would want to be protecting also, right? Is to say these are institutions with strong historic missions, and that if there's a problem in the accreditation process based on misunderstanding, lack of appreciation, or anything else for those missions, then there ought to be a remedy for that as well. And again, the single singling out strikes me as peculiar because the same kinds of things that, for instance, Kim pointed to about religion, I see in other contexts. I see much more in other contexts. And again, I don't know of any situations where accreditation has been withheld for failure to respect a mission, but I certainly see that the same sort of at least hypothetical problem with accreditors exists across a whole range of things.
Okay. So we'll take our time entering the door, yielding to each other. Thank you, though. So my reaction to that, too, is it did seem like the proposal shifted the focus, although I can understand it being helpful because I think that it's generally the case that accreditors don't understand the world of religious higher education as a rule. So that tend to be, folks from those contexts tend to be underrepresented on accrediting bodies, and there are different worldviews often represented. So what many people described here is, I think, a kind of widespread experience talking to peers who are accredited in a variety of different contexts of sort of, to use the language of my field, microaggressions or harassment that often occurs in the accrediting process. I could relay numerous examples from a number of professions, but I think you're right. I'm not aware of it yet having resulted in a final dispositive outcome that creates this problem. But I think there's a general perception that's coming and that there's a risk for it. And so I think that's driving a lot of interest here. Now, having said that, I am concerned more broadly about the shift here away from, and it seems like when we read, for instance, the comments we were given to negotiators of the intent of some of the changes in regulations, that broadly, it does seem like there's a desire to return to really giving deference to missions of all sorts. And I do think the move towards strict standard compliance and enumerated standards and bright lines has been a shift away from that a bit. And so it's interesting to see that. So, but in this one area, it seems like I think maybe the intent wasn't to say only religious missions really have to be scrutinized, but perhaps the way this 602.18 has been proposed to be rewritten sort of has that effect of conveying that that's the only thing this is about. And I'm not sure that's a great idea, even though I'm not against putting some legs on what it means to discharge that duty to respect.
Okay, so Richard, I really appreciate what you said about the missions of HBCUs. I agree. I represent the MSI community, and all of our institutions, of course, have great missions, in my opinion, to help the neediest of students succeed and achieve the American dream. So with that being said, if we look at 602.18, currently what's in statute now is this language that is basically stated here to some degree. So the agency must consistently apply and enforce standards that respect the stated mission of the institution. That within itself covers all higher education institutions. It's the stated mission. Now, the reason why the including religious mission language is there is because there are members of Congress that care about this issue. And so during the last reauthorization, there were members of Congress that wanted more of an emphasis here in this space. They offered amendments to do so. The committee took up those amendments. They were voted and passed, and it was included in the package, which normally is what happens when legislation is moving through. So different members will have their thing that they care about and that they're passionate about. As I read to you, based here in the committee report, Congressman Wahlberg was very passionate about this issue, and he articulated himself as such, and the committee agreed and saw fit, and we moved forward. They moved forward at the time. I was not working there then for the committee, but they moved forward, and now we see this language here. It seems like this language it's giving us pause, and I say that because we're going back and forth with should other missions be identified here? What does that look like? And what I wouldn't want us to do is go down this rabbit hole of starting to define each and every different type of mission, because we wouldn't be able to get all of them, right? So the language as it's written now, the stated mission of the institution, that seems to cover the bases, including religious schools. It is their mission, it's the mission of an HBCU, the mission of any MSI, the mission of any public or private, nonprofit or for-profit institution. It's there. So if we feel uncomfortable about, at the request of an institution, performs a review of their accreditor's respect for the institution's religious mission, then I think this conversation should shift to whether or not we feel comfortable with that process in general, when it starts, if it starts at the beginning, the end, or the middle, if we're okay with that, first of all. Second of all, striking religious mission, if that's giving us pause as a subcommittee, and just say the institution's mission overall. So every institution would have the right to request that a review be done by the accreditor, and that there be a written response according to their mission, regardless if it's a religious mission or not. It's just, you know, we're equaling the playing field for all, and it seems to be a theme at the Department of Education wanting to equal the playing field to some degree. So this would be another example and an opportunity to practice that. And then I think those were, or third, we don't like this at all, and we just want to get rid of it altogether. So I think those three things we should determine before we're able to report something substantive to the committee.
So I'm wondering at this point if I should go back to my suggested alternative, but perhaps we could hear from Steve, and then if there's no objections, I would move into that.
Yeah, I would agree with what Emmanuel said there, that you know, maybe one alternative is to strike the word religious in B right before mission and leave C the way it is, which captures what Congress was looking for when they added this language.
Okay, if you'll indulge me, so I'll pass along some copies of, this is basically what I did before, but with some adjustments. If you have copies, I don't know. So in the spirit of what we were talking about, again, I'm thinking from an operational standpoint, and I know it doesn't provide a preventative remedy other than accreditors knowing this process could come about. But what I'm suggesting here is the trigger be at the point of decision, really as part of an appeal review option for places. But then some of this would already be present anytime an accreditor deems a program to be out of compliance with the standard. They would be providing written documentation of that. But tying it specifically, since the context here is religious mission, to some additional steps that show that there's respect for religious mission. So that's my thought. This is again creating in my mind, a positive burden on the accreditor to demonstrate respect for religious mission, but in a way that's operationally feasible. So that's what I was attempting to thread the needle with. Anyhow. And I recognize that this is not a language that says there must always be an absolute deference to religious mission. And so I'm sort of working a bit against my faith-based job interests, but I think it's consistent with the way we approach a number of other topics here.
William, can you just walk us through how this would actually read in the regulation? I feel like I'm not understanding what that would sound like.
Okay.
So right now, there's this language about how the duty it could be discharged that they indicate their alternative proposal will take care of. What I'm recommending is that the lines be struck where it's being proposed that we say at the request of institution, a review of the accreditor's respect for the institution's religious mission. That line be struck, the next line be struck, and then in its place, there is I guess it would be a B with subpoints, and that's where that language would apply. So you have a written report indicating there's deficiencies in meeting standards, and then it would move into this next point. And I agree, this does not provide this procedure more generally for mission gaps of other sorts. I was very much aware of that. The only thing I attempted to do was to reduce it to one point with some bullet points rather than having it be the majority of points in this section. But anyhow.
Okay, so from a drafting perspective, I want to make sure let's make it make sense. Okay, so this would read, basically, we're taking the first paragraph, and we're still keeping that as is with the changes that we see here, right? So let's just take that last sentence. The agency meets this requirement if the agency, in the case of programs or institutions with a religious mission that are deemed by the agency to be operating with the compliance gap resulting from that mission, does the following, basically. That the standard is applied in a manner that demonstrates positive respect for the religious mission of the institution, semicolon, reasonable and substantial efforts that have been taken by the agency in its accreditation process to accommodate the institution or program stated religious mission in the application of the relevant standards, semicolon. And are we doing an and or an or here?
I would say an
And so all these things. And a compelling public interest that can only be satisfied by requiring the programs or institutions to comply in the least restrictive manner possible with standards. Okay. I just wanted to make sure I'm getting a good sense of your thinking and how you're actually proposing this, because as we know, and ors mean very different things.
It's very helpful.
Okay.
I've been thinking about the language too, and some of what you've done here, I think, helpfully is an improvement on what you had given us last time. But there are some terms that I think give me pause. So the requirement would be compelling written evidence of, and I'm not sure what compelling evidence means or who decides that. Maybe more significantly, the third bullet, a compelling public interest. We know what a compelling government interest is. I mean, that's a legal term that has content to it and developed case law. But compelling public interest is something different. I'm not aware of any sort of legal content for that, and it's not clear to me who would be deciding what that is. And another thing that gives me pause is in the second bullet point, it says reasonable and substantial efforts. When those terms are used in law, they mean quite different things, right? You have a reasonable justification means you have something that's sort of plausible, and if you have a substantial justification, it means something really weighty, and so they're actually in conflict. So I've been struggling with what this looks like, and maybe you can give us a better sense of, or maybe Stephen, you probably have some ideas too. It sounds like you're struggling with some of the same terms, maybe.
Yeah, litigators love reasonable and substantial. Right. That's all I was going to say.
My intent is not to give litigators more work. So
I'm not saying that's a bad thing.
My intent here is to have the highest bar that could be reached if we're going to justify restricting free exercise in this context. And I recognize that this is not written by a lawyer, so I appreciate the government versus public interest. I don't know if a compelling government interest would mean the same thing I'm trying to pull off there, but I think it probably would. Whichever of reasonable or substantial is the highest bar is the one I would want to have.
Bill, for those of us that don't have the accreditation background that you have, and can you just let me know what a compliance gap actually means?
I actually used that language because it was already here. So that's, and I don't know if there's a technical category for that. I would look to the Department of Ed to speak to that. I know what I perceived it to mean, but.
Yeah, wow. I would have, as part of accreditation group, maybe it's something that is particular to the religious institution that is kind of outside of an agency stand. Let's say, as an example, maybe a faculty qualification or the qualifications to teach a course. You know, most accreditors might say, you know, to teach a undergraduate level course, the professor has to teach at the doctoral level. But maybe in a religious institution, because of this guy's scholarly background, they want to allow this person to teach at that institute. That might be an example of a compliance gap. I mean, something like that.
Another possible compliance gap would be, you know, if an institution reserves the right to hire co-religionists only, well, you're doing a little bit of discrimination based on religion there when you don't allow someone to work purely because of their religious basis. And if the accreditation process was looking at compliance with, you know, Title VII or something along those lines based on religion, there would be a compliance gap there, but it's a result of the religious mission.
May I offer a compliance gap that was mentioned in another subcommittee? If a medical school were required by its accreditor to teach abortion to its students, and that was in the requirement for accreditation, and the school chose not to do that for religious reasons, that would be a compliance gap, potentially.
Thanks. Yeah, I wasn't suggesting substituting the word government for compelling government interest rather than compelling public interest, because that gets to, I guess, a bigger thing that I'm struggling with, which is that accrediting agencies are private entities, so they're not really in a position to define a compelling governmental interest because they aren't the government. And what, I mean, it was helpful to have, so last time, Bill, you gave us the language from the ABA and the APA, and I spent a lot of time thinking through that. As I understand what they did, they've decided to basically pretend that the First Amendment applies to them in defining how they govern institutions. And what I'm wondering is so they made that choice themselves, and I'm not, that's not a bad choice, but I don't know whether, I guess I'm trying to figure out what the implications are of the department telling accreditors that they should be imposing on themselves and therefore also on the institution's constitutional requirements. And actually, as I recall, I think that the ABA standard, as you gave it to us, talks about the First Amendment, and the APA standard talks about the U.S. Constitution more broadly. It seems like that's got a lot of stuff to it, that they've made a choice thinking through what they would do, and for the department to impose that on accreditors rather than having them decide for themselves, it's treating them like, like they're government actors bound by constitutional requirements and treating the institutions that they regulate in the same way. And I have a feeling that that carries with it a lot more stuff than possibly one means.
So it's 10:25. Why don't we take Haven and Bill and then take a 15-minute break?
Mine is more of from a 100-foot view, kind of clarity of process check. Because we've discussed a lot of different pieces of this. And to me, just in case it's helpful, there's a sort of order of operations forming in my mind that is sort of the first decision we need to make is, do we actually need a remedy here? Like, do we want to go down this path? Then the second one is, do we want a remedy for all missions or only religious missions? And then finally, if yes, we do want a remedy, what is the logistical process of that? And I'm not sure if we've actually agreed on any of those things, or if it's helpful to like at least recognize where we are all at on some of those things. But we kind of are moving around of a lot of different kind of categories and topics.
Your discussion is fascinating, Richard. As a complete amateur, I'd love to launch into issues like whether or not accrediting bodies are state actors and all those kinds of things, but that's way outside the scope of my competence. My intent here is simply that I see proposed language saying this is how you discharge the positive duty to show respect for religious mission, and the remedy that was being suggested seems to me like it's not feasible to institute, so I'm trying to suggest another one. I do think there is something different about how religious missions have to be respected from other kinds of missions because of the First Amendment myself, but or at least because of the doctrines of religious liberty that are reflected various places in our culture. But I think that's a more indirect thing. That really wasn't my motivation at all in suggesting this. So.
All right, let's take a 15-minute break, and when we come back, Andrew, you're up first. Oh, you're done. Okay. And then I thought Haven put forward a nice framework for continuing the discussion, so why don't we pick up there when we get back? Thank you. welcome back. We will take lunch break from noon to 1:30. I would love to try to get through the conversation that we started and then 600.9 and 600.11 before lunch, if we can do that. If not, we'll continue that after lunch. So I really liked Haven's framework for continuing our discussion about the accreditor review. She had three questions, they had three questions. Do we need a remedy for all missions or just religious missions? And if the remedy, what is the logistical process? Do people have thoughts about whether we need a remedy? Phil.
So I don't know that we need a remedy. We need a remedy if there's a problem. So I think we need an inoculation. That's the way I think I would talk about it. Because I suggested language, I don't want to misconstrue where I am on this topic. I do think it makes sense for us to have some guidance that helps with what it means to discharge respect for mission. I agree that with a number of the voices that have been raised, that it makes sense for that to be about all sorts of missions, and at the same time it makes sense to me that there is specific guidance about religious mission, even though I'm not sure it needs to be as long as either what is being suggested by the full committee or what I've suggested. I'm concerned about the particular solution recommended by the full committee for reasons I've articulated about feasibility, and I think that could be a much more complicated problem to actually implement than is being envisioned there, and so that's where I am on those topics. So.
Lynn, I really appreciate what the department has done here and the language that is proposed by the department. I think I would be in support personally of just keeping it as is. I think it does what Congress was concerned about, and is still within the department's authority there. So.
Okay, so I'm not an accreditor, of course, but I feel like this would be very burdensome for the accreditors if this language is going to remain as is, because the institution would be able to make a request at any point in time. The scope seems broad and vast, so I think that at least if the subcommittee is leaning toward keeping the language in as is, that we should talk about limiting the scope in some shape, form, or fashion to make it doable and reasonable. And yeah.
To answer my own questions, I do think we need a remedy, because we put in here protection, and then there's just, how do you operationalize it? You'd leave people with just a whole bunch of mess without guidance. So yes to remedy. I think it should not privilege religious mission over other missions, so I would propose striking the word religious out of points B and C so that we protect all missions, and that then the language then squares with the sort of preamble of 602.18. And as far as the actual logistics or operationalization of it, it looks really unwieldy right now. But before I get into the kind of weediness of process and logistics, I'd like for us to figure out the language. I would prefer for us to figure out the language of, do we cover all missions or only religious missions?
Something that I was talking about earlier over the break is that in the HEA, religious mission is an including clause. So it's just to kind of highlight a religious mission. With how it is worded in current law, there is no deciphering between an institution that has a religious mission versus one with just another type of mission, there's an including clause. So if we are going down the path of striking religious mission and to basically have that apply to any mission at an institution, I would like for us to consider in keeping the including clause as an option. And I'm not saying that I am supporting that. I'm just saying that we should consider that as an option as we are getting to our final conclusion.
My question goes back to what Emmanuel said a little bit before and about the burden factor, and I wanted to respond to Haven's idea of leaving the B and C in but striking out mission. I'm sorry, striking out religious. I can only gather that the burden placed on accreditors for in both B and C without the word religious would probably accentuate that burden even more, because now all of a sudden you're asking accreditors to provide a variety of written responses to a variety of perhaps open-ended missions. I just wanted to know if you had any thoughts about that. Can we do that again? Yes. So you made a point about whether or not that what level of burden was going to be placed on accreditors through this process. How, if we going with what Haven had put forth, taking out the word religious in clause B and C would it leaves it open-ended, and there are valid reasons to do that. I'm just wondering about whether or not that further accentuates the burden.
The answer is yes. So that's why we would need additional language in here to limit this. So, if we said something like in B, at the request of an institution performs a review of their accreditor's respect for an institution's mission, including religious mission, and provides a written response of the results of that review, and so on and so forth, there needs to be another subsection here that would say, and would have some type of limiting language that would say this could only happen however many times, if it's one or two or whatever we would feel comfortable with, or so many times within a year, up to 2 times annually or something like that. And as you were talking to me, I was actually thinking through what this would say, and so that's why I was
sort of to go back to what Kim said earlier. We had our first football analogy about throwing a challenge flag. It's hard to throw a challenge flag before the play actually happens, and you could be running into a scenario with that, and I just wanted to put that out there.
So I would agree that it seems to me for this particular recourse, it makes sense to tie it to the point of an accreditation decision. If there is some kind of unethical conduct or something else, there's usually due process procedures along the way, but that seems like a different matter to me than a accreditation decision. And that makes sense to me as the place where you're likely to have the most reason to take action and where it would make it a more efficient process. But I would be concerned with any time someone says there's a compliance gap with any kind of mission, then you get to do a special request for justification. Because anytime you document a compliance gap as an accreditor, you have to explain why, or there's action there, right? Potentially legal action, certainly, but also typically appeal processes within the accrediting body. And so this seems to be asking for another level of protection regarding perceived violations of that respect, beyond just, hey, you've told us we're not complying with standard whatever, now we want you to do another letter reviewing how you respected our mission and coming to that conclusion. That seems, to me, an unwieldy kind of process if it applied to every program, even if it just applies to religious programs, quite frankly.
So in speaking on the behalf of my constituency, I actually see the benefit in institutions being able to make this request if they feel like that the accreditor was acting in a way that was not respecting the mission of their institution. I think that is very appropriate due to the relationship that an institution has with the accreditor, and it further, allows there to be a fairness in the process. As you know, there are institutions that when an accreditor makes a decision, that's that. In the statute, there's a way that you can appeal that, and I think they have two different options that they can try to seek some sort of appeal and hope for the best. But overall, in my opinion, this strengthens the relationship between the two. But, which is why I go back to my statement earlier of having some language in here to limit this scope in some shape, form, or fashion so that it's not too burdensome, but we're not taking away an opportunity for an institution to ask this very important question and seek clarification if needed.
So thinking through a scenario, imagine, for instance, again, when you're documenting a compliance gap, an accreditor knows this could be an issue they have to address. Essentially, this becomes functionally an automatic right to make a motion to reconsider every time a decision is made. So what if they put that rationale for why or how they respected their mission in the initial letter of decision? Could they say the duty was discharged then if they did it before it's even requested?
Well, I guess in that scenario, the answer seems like it would be yes. If it's already included, then I guess what would the institution then ask further clarification for? But at the same time, I think that if the institution needed further clarification, that they should be able to request that.
Bill, for those of us who haven't ever seen these letters before, what do they normally have? If they go through and identify, so I use the term compliance gap or whatever, would it normally just be a list of things, or do they explain, or how do they do that? Because I'm wondering getting to what you just posed, what's there normally, what the kind of regular practice is right now?
So I think Herman could probably speak more generally to this. What I've seen in a variety of different accreditors, from regional to programmatic, it is a listing of areas of compliance concern. That could be, technically, if a program's out of compliance, there should not be a positive decision, but often there will be areas where they want additional information, reporting requirements, or I think there's some language used that's being proposed about monitoring versus compliance reports or something like that. But it'll be a document that lists a reference to a specific standard and what the judgment of the review body is. And then there'll be some specific thing that the institution is being asked to address as a result. If it is something that results in a negative decision, typically then that's gone through a legal review, and there'll be a detailed description of what the basis for that negative decision is.
Oh, that's exactly what I was wondering. Is so they would tend to have some concrete, not just you're falling short on whatever our standard is X, but here's why we think that, and so there would be some meat to the explanation.
Well, I
don't know how far that goes.
It'll be written in language that it'll be sort of a language that they've come a convention, but there will be a basis there for the decision, particularly if it's an adverse decision that's articulated. The goal of accreditors is not to disaccredit, but to enforce quality. It may not feel that way when you're on the receiving end of the review process. We have a site visit later this spring for our program, for instance, and a regional accreditation in a couple of weeks, so at our institution. So it certainly feels like something else is going on at times when you go through all that scrutiny, but the goal is to enforce quality and to maintain quality within a set of standards. So
Yeah, I did. I just wanted to say, yeah, some of the decision letters that the commissions put out, or the boards, whichever term they use for their decision-making body, they're pretty lengthy and pretty detailed. You can have them from as many as 20 pages to 30 pages, and they kind of explain what the issue was, and they also give a corrective action. They talk about the appeals process. So that's, they're pretty self-explanatory. So between that document and then the site visit report, which gives the initial indication of compliance or of the site team's recommendation of evaluation of compliance or non-compliance, then of course the decision letter being the final document, there's some pretty good explanation of what the issue is. The other thing I just wanted to bring out quickly is that don't forget about the self-study process. So, before the accreditation process starts, the institutional program has to complete a self-study. This could be helpful in that process too, whereas as the institution is going through the self-study, they see a red flag and they ask for this review at that point too. So that's just another area for y'all to think about of what kind of parameters you want to put around. I just wanted to bring that up, is that the self-study process is pretty is a good place where
So I just wanted to ask a question, and then I had a comment. But so what are there sounds like there are 3 stages: the self-study, and then the initial findings.
Right. So what happens if we look at the accreditation process, big picture, and I won't go into great detail, but big picture, at some point before the site team arrives, the institution starts their self-study process, and wherever that timeline begins, and the self-study is what the institution uses to tell the accreditor how it meets its standards, policies, and procedures. So, when you're going through that long self-study process, if the person in the institution who's writing a self-study, or the groups, because usually it's groups of folks who take on particular sections of agency policy and standards is going through this process, I was just saying, at that point, if they see an issue that raises concern, that could be a place where this process may begin, of where that institution goes or program goes, oh, red flag, let's ask more clarity about these issues. I just didn't want you all to forget about that self-study process being something that begins well before the site team shows up. And then when the site team gets there, their job is to verify all of the information that the institution or program put in its self-study to see that the institution or program is actually operating as they have written.
I wanted a little, so then how soon after the site visit is it initial report, or you used a term and I forget what it is?
Just from my experience with my agencies, the self-study comes in, the site visitors come in, and then once the site visitors do a report on the self-study, they give them some time to respond to the report from the visitors, the agency visitors, on the self-study report, and then all of that is captured and presented to the decision-making body.
But I'm wondering, so just trying to figure out, I'm just thinking about B right now, and, the concern about whether this could be abused. I think, I'll say what I'm thinking about it, and then,
Sure.
give me information here.
Sure.
But basically, I think B makes a lot of sense, whether it's just for the religious mission or all the missions, that if the institution is seeing a problem with a particular visiting accreditor, that you would want that flagged early in the process before the whole process is gone through, rather than making it part of the final It just seems like it's more efficient and beneficial to everyone if there is a place early in the process where someone says, I've got a problem with something about this person, cause concern. But but it needs to not be abused, so probably the number of times you can ask for the review needs to be addressed, but also, I'm just wondering if you say red flag has to be raised before the initial report back, or probably you want the red flag to be able to be raised once they've gotten the initial report. But I'm trying to figure out, like, is there a time frame where there'd be a logical cutoff?
So first, let me go back to your first part of your discussion. So kind of like two tracks. You know, the institution being accredited has an opportunity to, under conflicts of interest, to, at that point, inform an accreditor that they have a problem with a particular site visitor. So that's a different requirement. But all of the institution programs have that opportunity. The accreditor has to then say, these are the folks that are coming to do the visit. They have to give that institution an opportunity to say, okay, we don't have any issues with that particular person. Now, the second part of your question is that once the site team completes the report, then again the institution has, and it varies, they have time to go over the report, and they have time to say whether the information in the site visit report is accurate. So, and that's in current regulation too. They have to be given that opportunity to review the report. So issues can also come up at that point before that report then gets forwarded to the agency's decision-making body. And then that process can take time for the decision-making body to look over all the information. I've sat in commission meetings where the body is looking at a non-compliance area, and the commission will say, well, we just don't have enough information. They'll defer that decision. So a lot of those aren't taken lightly, and that thought process is pretty detailed and in-depth. I hope I answered your question.
So maybe, I mean, just to throw out there for discussion, maybe the one parameter is the number of times, and then one parameter is the timing in which a request for review of an accreditor has to occur. And it could even be, you know, like within a week of receiving this initial report, like just having a cutoff where you do give the institution a chance to say, we were uncomfortable afterwards, because they might not in the initial, during the self-study process, they may not just know the person other than their qualifications on paper and such, but there could be something that happens during the site visit that triggers their concern. So, you know, just trying to define that gap time-wise so it's not abused, but it does give a chance to let everyone know there might be a problem before the whole thing has been carried out.
I did just want to add, they do have an opportunity to add additional information, during those conversations in that time that the institution gets to tell the agency whether they got everything right, right or not that first time. And then that review is kind of based on, you're really looking for inaccurate information, inaccurate evaluation. So I don't know if it wouldn't capture a personality conflict unless that led to, an inaccurate decision based on a person's perceptions or feelings, more so based on the actual factual information obtained at the site visit during the site visit.
So I'm nodding, but I want to be sure. So basically, this is a slightly different type of concern that wouldn't necessarily be addressed in that initial period of saying we don't agree with your factual findings. This is a different kind of concern.
I think what you brought up was a concern about maybe a personality issue and a person's feelings or beliefs about a particular institution. The response to the initial site visit report is really based on on factual data, which would capture if there were this so-called gap that we're all trying to figure out what you guys are trying to figure out what that might be. It would identify those issues, because then the institutions could say, well, hey, wait a minute, this is this is how we do things, or which may be a little contrary to standards. But so I think it would capture that type of information. It just wouldn't capture, I think, the issue that you brought up, which would be the personality conflict. Again, unless that personality conflict translated into that site visitor finding a non-compliant area based on no justification at all.
So I think just for folks not involved in the accreditation process, a couple things that might be relevant is site visits are in many cases not done by members of the decision-making body, but by professional volunteers. In some cases, they are members of the decision-making body that go out to visit and look at an institution in operation. But even in those cases, they're not making a decision. Their function is like eyes and ears for a decision to be made later. Even the preliminary review of the self-study and questions asked is fact-finding, as you said, or to point out discrepancies and ask for clarifications in what the program itself is self-described. So it's hard to know. I mean, it's often the case that a site visit report will say things that do not reflect the judgment of the commission, and site visitors are typically told not to do that, but they're volunteers in some cases. There are some professions that pay, or accreditors that pay for people to do this sort of thing. But it's a complicated situation when it comes to this. So it's only really at the point of decision that you know what the accrediting body thinks about the record, right? So now, could there be biases along the way? Well, I will tell you, several years ago, one of our programs going through a specialty accreditation, we were 2 weeks out from a site visit, and the site visitor presented at a national conference. One of our students was there, and the person said in the course of their presentation they didn't think any faith-based program should ever be accredited. Okay, we decided at that point, should we appeal this or not? We were confident about our record. It would have delayed our accreditation process. We went through with that site visitor, and the area where that person reviewed us in the self-study did not reflect any negative language or bias in what they wrote. I think they didn't change their general point of view philosophically, but they applied the standards in our case in a way that we felt was fair and reasonable, and it didn't do any adverse action to us. And all that the accrediting body saw in that case was what they sent in the site visit report. So they weren't there to discuss their impressions beyond that or anything else when the decision was made. So certainly if there would have been an adverse outcome, it would have given us something to talk about with the accreditor. And we could have handled that in a variety of ways of consultation during the process with the accrediting body, that sort of thing. And so that's why I think it's the number of times this is used to make sense to limit that, but I don't know practically a formal request for a review how you're applying respect for our mission in a written form, give us a report. It seems to me like you wouldn't know what the accrediting body is really doing until they're at the decision point, because that's the point at which the body makes a decision. Before that, it's various consultants that they use or pieces of the commission or staff looking at things, and you don't yet know what they think.
So I very much appreciate the context and the practitioner perspective. I have not been part of an accreditation process. It's not my organization, but I have plenty of colleagues in the higher education space, so I know how high stakes this is. And it sounds through some of the descriptions that we've gotten that there is a well-defined set of guardrails in place for the various scenarios that we have, the hypotheticals that we have thrown out here or discussed. And it seems through both examples that those guardrails seem to be working. So going back to the question of remedy, I guess my question is, what we're talking about here is a second set of guardrails, a set of guardrails inside the existing guardrails for accreditation. And do we have either examples or evidence to indicate that there is a need for a second set of guardrails that already exist within the current guardrails. I myself haven't heard any compelling, there's that word compelling, I haven't heard any compelling reason why we need a second set of guardrails. I appreciate Emmanuel's historical context that we even got to the word religious mission here because of a legislative process. And, you know, with an HEA reauthorization forthcoming eventually, would this not be something that if a member of Congress or an elected official wanted to, you know, put forth, that would once again happen through the legislative process as opposed to creating guardrails inside guardrails inside guardrails?
So I appreciate what you said, Andrew, because that actually goes back to an initial concern that I had with, you know, this particular process, the fact that Congress is looking at reauthorizing the Higher Education Act. Who knows if that will actually happen this Congress? There is, you know, they're moving full steam ahead to try to make it happen. If that's the case, then probably what we would see from Congress might look differently than what the department is proposing. I would say 9 times out of 10 it would look different. So therefore you have institutions that are trying to abide by regulations and do the right things and be in compliance, and then Congress would hypothetically come out with something new and say, okay, well now institution A, you have to do this now. So the timing of all of this, you know, presents a challenge. But besides all of that, I think that it is important as we're looking at this to even determine if we want this as a committee. So I would like to propose that we discuss, do we want this to remain or not first?
I appreciate Andrew's use of the term guardrail because C really is a new guardrail. Part C there is basically that you can't deny and postpone, you can't punish the school before they've had their day in court, so to speak. And so that is kind of a new guardrail, the way I'm reading it. And it might be that because of the case that was mentioned earlier, but that is a new part in that.
One of the distinctions is that the guardrails that do exist within the accreditor. So this is an opportunity to appeal beyond the accreditor standards. So that's slightly different. The other thing I would mention, not intending to mess things up tremendously, is we are kind of discussing mission as though it is evergreen. And in fact, having sat in HLC presentations for the last 5 years, they are constantly encouraging institutions to rewrite their mission. So I think it's important to know that if that's the case, somebody could play games here rewriting their mission to avoid a standard. I realize that's a completely negative approach, but I think the intent of this is to say a real fundamental, permanent aspect of an institution is what's being in question.
I was just going to say in answer to Emmanuel's question for me, I like this. I like the way it's written. I like the practical impact of it. I like that it's the agency clearly interpreting and applying what Congress has said they're concerned about.
I guess the question is for the department of, are there other examples of in which, and we'll stay with the metaphor of guardrails, are there other examples in which additional guardrails have been put inside the existing guardrails that surround the accreditation process? I mean, it sounds like there already is an appeal process, that there are mechanisms, and are there other examples that you know of that go outside that appeal process? As this would potentially do.
No, because I think this mission issue is a little different. I just see this as a way for an institution to ask an accreditor for review of standards, maybe prior to the process. Beginning, as I mentioned, and I know the site team as William. I'm sorry if that's what William was saying is true. This is just a place where an accreditor, a institution could come in and say, hey, could you review this? It's kind of like to me, I see it as a preemptive measure. Again, I say as the institution is going through its self-study process, and they're saying how they comply with something, and they go, oh well, we may need another interpretation of this. So I don't classify it as a guardrail inside a guardrail. I just classify it as it appears to me to be a preemptive measure to help solve problems down the road that don't need to occur. That's kind of the way I look at the issue.
No, I was just going to say, within higher ed, as you go through that accreditation process, very practically speaking, we're terrified of the accreditors. I mean, the institution, you have these appeals processes within, for us, the Higher Learning Commission, but no chief academic officer wants to raise their hand and say, you really need to look at what you've done. And so as a practical matter, those appeal processes are not used very often at all, just because you don't want to get dinged by the accreditor. So something like this, I think, would help an institution to have just another outlet to say, show me how you have respected the mission like you're supposed to.
So I guess I had a question, because I thought I understood what this did, and then I think you and I maybe have a different view, and so I don't know which one is right. I understood this to be all within the accreditor, under the umbrella of the accreditor, and I think you took it to be something that stands above the accreditor. Which one is right?
In that it's in the regulation. I took it to be, if an accreditor does not respond appropriately to this, then the department could review that in terms of their recognition of an accreditor. So that's how I was seeing it beyond that.
And do you think that is different? I'm just not sure whether that's different from what A already provides, that it's in the regulation. A as would be, I guess, I don't know if it's A, but provides the institution a program with detailed report, whatever, that I take it that can go to the department if I'm an institution and I'm unhappy with the report, there's a process that's the process that you told us about last time that gets to the department, right?
I guess my reading, and Herman needs to speak to this, is that this is the equivalent to an institution having an opportunity to respond to a site visit. But with the intention that it go to the decision maker in the end. I may have misread it, but that was my interpretation. Yeah.
So a slight bit of thought here that it could be a bit of a distinction, although it is something that I think then, since it is another regulation, could be part of an appeal or complaint, I guess, to the Department of Education. It does create an extra step, that is, in addition to whatever normal appeals process may exist for an adverse decision within an accreditor, separate of having to do that, say we just appeal your whole decision, you can say, we want you to relook at whether or not you respected our mission on that one point. And so it creates an extra step before it would rise to the level of a complaint, which is something that would be, I think, relatively extraordinary. It doesn't happen often. I think probably a complaint to you above an accreditor's due process options.
Well, I would just say I agree with what was just said regarding the ability of institutions to be able to seek a review if they need it. But from these conversations, it sounds like maybe if this is something we wanted to keep, which I haven't heard otherwise, that we did not want to keep the language, I don't think. Maybe someone said that earlier. But at the request of an institution during the review of the agency report, performs a review of the accreditor's respect for an institution's religious mission as an option or something like that before it gets to the decision-making body, or tie it to the decision-making body's decision ultimately. But some kind of language there may help as at least a starting point if we're looking at that.
So I was for quite a while now. This morning, I've been focusing on the additions B and C, or B, C, and D, and I actually just went back and looked at what was there originally as the A, B, C, and D, and I'm not sure that it doesn't do most, maybe not all, but at least most of what we think ought to be done and done generally here. So I wonder, Lynn, if you could speak to the department's rationale for getting rid of A through D in the current reg. I mean, those are all the protections generally for, making sure that there's consistent application, there's standards, there's, and then it's all under the heading of respect for the mission of. Yes, there's an added piece of the when you can ask for a review, but those all seem like good things to me, and I wonder, as I say, I wonder what the rationale is for getting rid of them and then putting back in sort of, charged or tuned up versions only for religious institutions. I don't know why those wouldn't stay in place to begin with.
Yeah, I mean, there was an interest in focusing on the religious mission. Certainly we can discuss leaving the language or editing it.
What was the rationale for removing it? I mean, because if the department had a particular interest in focusing on the religious institutions, look, I think there may be a constitutional problem with creating special appeal rights for religious institutions only and not others. But setting that aside, I sort of don't know what the rationale is for removing all the stuff that's being removed, which doesn't seem to have anything to do with religious mission or otherwise. It seems like there's something else going on there, and I just don't know what it was.
Herman?
And there's been problems with this section before this started. It's just that a lot of the language here is taken care of in other areas of the criteria for recognition. When we talk about agencies must have standards. The standards criteria is covered under 602.16. So it's already in other places. So that was a rationale for taking. For taking that out, where it talks about basis decision regarding accreditation, pre-accreditation agency standards. We already do that in other places. And then I think the other strike was reasonable basis for determining that the information the agency relies on is accurate. If you look at the totality of the criteria for recognition, that this stuff is taken care of in the whole context of the requirements for agency recognition. That was the reason for taking that out.
That's helpful. When I read that language, it strikes me as language that would be almost boilerplate, that what a program would say to answer the original language, it would say to every program, and sort of is against the spirit of this section, which is about sort of adaptive respect for the mission of individual institutions. And so it made sense to me that some change occur, but I agree that it goes in a different direction when what replaces it is just focused on religious mission. So I like Emmanuel's suggestion about if we take the new language and then tie it to decision points a number of times, and maybe you said earlier, mission in general, including religious mission, that seems to me like it is a both-and approach.
So my question to that would be, is there a preference? So if we look at B, at the request of an institution during a review of the agency report, does that suffice, or should it say something different there? Yes. So at the request of an institution during a review of the agency report, performs a review of the accreditor's respect for an institution's religious mission. So basically, there's a time frame. It's during that particular period. You can request a review. And we could even say performs a one-time review of the accreditor, something of that nature.
So I wish I had noticed this earlier. So last night, from Aaron Washington, we got new redlined versions of 602, and so there are actually some changes in this 602.18 section that came out last night vis-a-vis what we're looking at right now. They appear to be mostly technical in nature. The word response is replaced with the word report, but it would be helpful to get something from the department maybe after lunch about whether or not there are any substantive changes relative to 602.18, or were there changes in anything else other than 602 from the previous redline version that makes some of the conversations that we're have put it into a different context.
I have the latest copy here, so it looks under B, it looks pretty minor. I think the only other thing I think you guys might want to think about report. Which report are you talking about? Is it the site visit report? Is it the commission's decision letter? You probably need to discuss which one of those reports you want to.
So last time I'll say this, and then there's so much variability across some specific details in how this process plays out among different accreditors that I think the point that makes sense still to me is to have this take place at the point of decision, of an accreditation decision, which could be a periodic review. It could be a decision on a follow-up issue. But when an accreditor has, because that's the only point at which a full accrediting body's made a decision and reviewed the record. Before that, there's so many ways that there could be variability, unrelated or undeterminative, I should say, of the final outcome. So.
So I think the language manuals sounds good, with the one caveat that I think it's also important to have an opportunity to raise a concern about an accreditor visiting team member when after the visit, right after the visits happen, because quite honestly, we've heard at least one example now, and I read one example of, there is a bias sometimes against religious mission or just in ignorance of it. And so I think personally, if I heard what you all had heard, I would want to bring it to the accrediting agency's attention immediately for the reason that you were also mentioning, which is that the longer it goes on, the more delay. The delay is what kills you, right? That's the delay's part of the problem. And so I just would add language about maybe within 3 days of the visit or something where they don't have to wait for a written response from the accrediting agency first to see if there was a problem. They can just flag it initially as well.
I would just say that we have an open pathway. Most everyone in our specialty area of psychology can call up our director of our staff directly, of our office directly, and consult. So that often happens. There were other conversations other than what I described to you in the wake of that particular comment, but we had the option, I think, of voicing a conflict of interest and having them removed, and we would have suffered a delay in the process. That is not, though, a negative action by itself. It's just, it extends reaccreditation, but the further away you get from when you have that snapshot in time when you write a self-study, the more things could change, and then you have more explaining to do, and it can just create complications in the process. So I certainly like the idea of them being mindful, accrediting bodies being mindful of this need to respect mission throughout the process. And I personally am sensitive to the religious mission issues in the context I work, but I've seen it where science folks go to visit practitioner programs, or there's lots of ways that mission bias can be an issue. And I think the idea that this being a generic protection makes sense to me, as long as it's clear that it includes protections for religious mission as well.
All right, I'm just going to ask a question. So, if I can, by show of hands, who supports keeping the language in here in some shape, form, or fashion?
Are you saying the department's recommended language?
I'm saying the department's recommended language, but maybe with some modifications. Like, we definitely want language to still be here. Like, we're not saying just remove it all, or, B and C, or B. Let's just talk about B right now. We're not saying just remove B entirely. We're just saying, yes, let's keep B, but let's modify it a little bit so we feel better about it. By show of hands, who? Yeah.
I'm sorry, can I add, just ensure that you look at the new language that was sent out last night. I don't know if you want to look at that, because it has changed from what you had initially for C and B.
So I looked at it. I can read it. I have it here. I didn't think it. Oh, the compliance gap.
Sorry. Oh, what I said was B looks identical except for changing the word creditors in the previous version to agencies. C, right, it now would say due to an institution's adherence to its religious mission and any of its policies and practices. So it's, so it's changing due to a compliance gap that is the result of due to an institution's adherence to its religious mission. That's the. And D, D is more different. D, instead of agencies must publish any policies for retroactive application of an accreditation decision, would become publishes any policies for retroactive application of an accreditation decision. And there's a kind of a long comment in the margins here. I don't know do folks have it? Do you want me to read it? Do you want, okay. All right. This is a test of my reading glasses, though. It's very small. Because students let's see, because students enrolled at public or nonprofit institutions may participate in Title IV programs once the institution or program is pre-accredited, it is important for those students to benefit from an affirmative final accreditation decision, even if it isn't made until after the student completes a program. As long as the student was enrolled in the institution or program during the period of pre-accreditation that resulted in the final decision, all credits earned during that enrollment are considered to have been earned from an accredited institution or program. Some agencies require up to 5 years of pre-accreditation prior to a final accreditation decision, require a cohort of students to graduate from the program before a final accreditation decision will be made, or require an institution to undergo an extensive review subsequent to an approved change of control. Therefore, it is necessary for those agencies to retroactively award accreditation to ensure that the students' interests are served and that taxpayer dollars used to support the student's enrollment will enable the student to work and repay their student loans. I told you it was long. New paragraph. Without retroactive accreditation, new institutions or programs would be required to graduate at least one cohort of students from a program, even though students who completed the program would have no chance of having their credential recognized as accredited. This would be irresponsible for an institution to do and unfair for the students who may unwittingly go through such a program. New paragraph. In 2017, the department issued an announcement that retroactive accreditation was impermissible. The department rescinded that guidance in 2018 and now wishes to codify the permissibility of retroactive accreditation and regulation. Oh, now you've got it up. I was going to say if anybody wants me to pass this around, I'm happy to, but.
I've been sitting in, we're listening to the Distance Learning and Educational Innovation Committee, which went through this in detail. A clear example is if you establish a nursing program, the nursing accreditor will not accredit the program until you have your first class graduated. So that's the 5-year gap. Without this language, the students who enter your program might lose all of the financial aid that they had received while proceeding in the program if at the end of the 5 years when the students graduate and don't pass the nursing exam, for example, and therefore the program is not accredited, all of the students who were in the program up to that point would be without remedy. That's the source of this change.
And I would just add that this language really is not different. It's doing the same thing. It's just drafted in a way that actually makes sense and flows better than what we originally had.
Yeah. I just wanted to provide a little context. The full committee is looking at all of the accreditation provisions. We're just looking at the ones that specifically relate to religious mission. So B and C are very relevant for us. I think D is being discussed by another group, and we could go down a long rabbit hole on that. So I don't think if you're not familiar with the retroactive accreditation, I don't know that it's relevant for this discussion here.
So having been through this process as this change has occurred, I certainly understand why it's being addressed, but that's what was my reaction to. It just seems a little odd to be in this section about consistency of standards. I guess it could be if you're saying you're going to allow a program to be retroactive accredited, presumably when they're getting started, they're not inconsistent with every standard because some things won't be in place yet. And so I suppose that's why it's here, but I agree. It seems to me like it's a different focus than our task.
I can take back to the other group the comment that they should think about whether it should be somewhere else.
So I wanted to pose my question that I posed earlier because we have 10 minutes and then we have to break for lunch. So I just think it would be helpful if we kind of can take a temperature check before we break for lunch. So the language in B and C, is there anyone opposed to having some version of this language included?
And again, you're saying the proposed red letter language.
Yeah, like any
Okay.
version of
I
that.
wanted to make sure you weren't backing up to what Richard had said about
Or
the ones that were being pulled out.
the new
You're talking
that,
about
that we
the
see
new-
here,
okay,
B
thanks.
and C, that we see here. Is anyone opposed to having some version of that? Okay, seems like no one's opposed to that. So it seems like then we are now talking about how we want to reword it in a way that makes sense for those that we are representing here at this table. Right? So based on that, then from previous conversations, there was some pause with religious mission in the way that it's written now, and there was conversations about saying mission overall. Is anyone opposed to that? Is anyone opposed to, instead of saying religious mission in B and C, saying mission only, without, we haven't got to the including clause yet. Just saying mission. Is anyone opposed to that? Is anyone opposed to saying mission, comma, including religious mission?
In essence, what you're asking is whether or not people would feel comfortable, because this mimics the heading of a 602.18. Is that what you're trying to accomplish from a parallel perspective?
Yes. But if people are okay with that. Okay, so from what we can read here, which says, So at the request of an institution, performs a review of the agency's respect for the institution's mission, including religious mission, and provides a written report. So that's in B. Would we also want to make the same change to C?
I think maybe before we get to C, we might want to go back to where you started us several minutes ago on the limitations on the timing and all that for B, because it seems like that is going to, is going to affect whether C is necessary and what it does. I'm not sure of that, but I think so.
I will say, while I don't have any objection to what's being done here, I do have to question whether or not it's the scope of this subcommittee with our name to all of a sudden add the word mission without the word religious in it. I'm just wondering whether that will be construed as overreaching for what we were intended to resolve.
I think that's fine. That's within the scope of what we're discussing.
Thank you.
Okay. So that's okay. So it looks like that we all feel good with saying mission, including religious mission. Now, Richard brought up a good point regarding the scope. And so earlier I had suggested some language just talking about it, but in B, at the request of an institution during a review of the agency report is what I had suggested, but there may be a better way to say that. And Bill, you may have a better way for us to say that, or the timing of that, or what that would look like. If there are any thoughts around that.
So my trigger would be pretty black and white. So it would be in response to a communication, any communication of a accreditation decision. So typically that would be the accreditation decision letter, but that's what I would say. I understand the process protections and would appreciate them, actually, that Herman has talked about. It just seems to me that the process is too nebulous across accreditors before that. Understanding there already are mechanisms for consultation and to put on record concerns if you have a conflict of interest and things like that.
So then how would you propose we word that?
In response to an accreditation decision.
Actually, I just wanted to ask Bill a follow-up, because that seems very logical to me. I know you've been concerned about and have reminded us about the burdens that would entail. I take it you think that would be sufficiently constrained not to be unmanageable? I mean, you'll be in a far better position than I to have a view on that, so.
If everyone does this and says, what about our mission? We want you to reconsider, then we need to have twice the meetings. So that's, presumably that's not how it's going to be put into effect, but it's a recourse, right? So anytime you add an additional recourse step, that could be extra to work. So it's I don't think most programs would do that, but I can think of a variety of different kinds of missions in our field where people could say that drives some of the way their compliance is being evaluated. So I don't think it's a bad thing if it's tied to a discrete point, and if it just depends on how it gets fleshed out.
Again, whatever language you all come up with, I think, though, you need to make a clear decision in the regulation if you're talking about the report of a site visit or something else, or a report of a decision. So I think you need to, however you want to do it, I think you need to clear the language up there to clearly indicate that you're talking about an accreditation decision made by the formal decision-making body.
I wouldn't say final because, you know, it's
Yeah,
a dynamic process.
Final would indicate after appeals and all those things that, you know, that were to happen.
I guess I still see this as an opportunity for the institution to have an early chance of saying they have a concern. And so to wait until the end just puts it into the general process of challenging the decision itself. And I thought the purpose of this was to give an early, an ability to flag a problem early. So I wouldn't want it to be during a review of the agency report. I would think you'd want it to be, you know, within a week of the site visit, or within a week of receiving the initial report, rather than, you know, putting it off to the end.
Oh, you're probably going to talk about what because I understood you to be saying before there are mechanisms there to engage before that. Because I appreciate the concern, but I had understood you, Bill, to be saying that there's already something that allows for that process. I don't know if you can speak a little bit more to that and what you think is useful or not.
So I think many accrediting bodies would have informal procedures. So this is a formal procedure. The question is whether or not we want a formal process at an earlier stage. But the site visit, for instance, it's often the case that you don't receive a site visit report till at least 30 days after it has occurred. And that, again, still, for many accreditors, is not the evaluation of the accrediting body, but you are allowed to respond to it. Well, you're encouraged to respond to it anyhow, and you have a time period to write it. Then the accrediting body reviews both the site visit report and the program's response to it. So we talk all the time with initials. So SVR, RSVR, that's how we refer to them, right? So we have acronyms for them, and so both of those now are part of the record. So I know it's possible you could have bias, and an accrediting body being insensitive to bias. It seems to me if that was occurring at any point of the process, at a minimum, even under the existing language, that could be the basis for a complaint to the Department of Ed if they didn't take it seriously and respond to that. Even with the way it's worded now on 602.18, I suppose someone could write in and say they're not operating with respect for our mission, and just say that and say, here's what happened, and described it. And so I'm not so sure there isn't recourse already in that kind of a case. So I wouldn't know what an accreditor had done to respect a mission in our program until I've heard what decision they reached. that's just how I would respond to it.
Hearing you describe that process, and I remember we just went through our accreditation with the Higher Learning Commission last year, I believe it was, but having the ability to respond to that site visit report might be a helpful thing as well, to flag that before it goes to final decision, to say, tell us, we've got issues here, tell us about that. And then another opportunity after the final decision to say, okay, HLC, tell us how you did this, you know. So I think there are probably two trigger points there that would provide ultimate kind of protection without being too burdensome.
So I don't want to cut off this great conversation, but we've reached the noon hour and the live streaming is going to go down. Well, first of all, congratulations. I think you're very close to having your first recommendation to the full committee. So I hope that when we come back, we can get the last details hammered out. And then we'll move on to 609 and 611. So we'll be back here at 1:30. And I hope everybody enjoys lunch. If you need restaurant ideas, let me know.